Leasehold Estates is an estate in which the tenant has present possessory property interest and the landlord has future interest or reversion. For leasehold estates, one, we have tenancy for years. So this lasts a fixed period of time. It requires a definite beginning and end. If duration is longer than 1 year, a lease must be in writing, required by the statute of frauds, termination automatically at the end of the fixed period, and there's no notice is required. So also referred to as an estate for years, term for years, or fixed term tenancy. 2, there's a periodic tenancy. So this is a tenancy estate that repeats until terminated. And then there's tenancy at will, which is either party can terminate at any time without notice. And then 4th, there's tenancy at sufferance, which is a tenancy has possession by virtue of wrongfully remaining after termination of a lease. Holdover tenant. So periodic tenancy is a leasehold that is continuous for successive intervals, so weeks or months, until either party gives notice of termination. So the creation can be express, implied, or by operation of law. Express agreement is conveyed to the tenant for agreed interval. Implication is a lease that does not specify duration but provides a rent to be paid at set intervals. Operation of law can happen in 2 situations. One, where there's an invalid lease. If tenant takes possession despite an invalid lease, so the lease violates the statute of frauds. There's periodic tenancy arises upon the landlord's acceptance of payment. There's a period of the tenancy is determined by the period the payment covers. And the other is a holdover tenant. So if landlord accepts the rent from a holdover tenant, a periodic tenancy arises for the period the payment covers. And then there's termination. So a tenant must give proper notice, which requires 1, sufficient time. So the tenant must give notice 1 full period in advance. Year-to-year tenancies require 6 months notice. Or 2, an effective date. So an effective date of termination must be at the end of the period of tenancy. Note, parties can agree to modify these requirements. Then there's a tenancy at will. A tenancy with no fixed duration is terminable by either party at any time without notice. The creation is an express agreement. This is without an express agreement, courts will treat the lease as an implied periodic tenancy. Termination by will or operation of law. So by will is either party can terminate the lease at any time without notice, but with a reasonable demand to vacate the premises is usually required. By operation of law occurs upon any of the following: either 1, death of either party; 2, waste by the tenant; 3, assignment by the tenant; 4, transfer by the title by the landlord; or 5, lease by the landlord to a third party. Then we have tenancy at sufferance. This is a default tenancy that arises when a tenant continues to possess property after the lease expires. So this is a holdover tenant. The creation is that tenant holds possession beyond the lease expiration. The expired lease's terms and conditions automatically carry over to the tenancy at sufferance. So the landlord options are 1, sue to evict, or 2, impose a new periodic tenancy. So raised rent, a landlord can demand higher rent for both the holdover period and any new periodic tenancy if he gave notice of the increase before the lease expired. Then there's commercial leases. If expired, lease was for 1 year or longer, the new periodic tenancy can be year to year. The exception is imposing new periodic tenancy must be reasonable. The new periodic tenancy is unreasonable if tenant only remains in possession for a few hours or tenant is not at fault for delay in vacating, such as illness, or there's a seasonal lease, such as a ski cabin or a beach house. Tenants' duties at common law. So tenants have a duty to repair, and this can largely be modified by lease terms. So a tenant must maintain premises and make ordinary repairs. Residential tenants have a duty to repair, is modified by the implied warranty of habitability. Tenant must not commit waste. So there are three types of waste. There's voluntary, which is overt harmful acts such as removing fixtures. There's two, permissive, which is neglect. And then there's three, ameliorative, which is alterations increasing property value. And then there's the destruction of premises. Without fault of a landlord or a tenant, the common law is that tenant held liable for any loss. And then there's modern law, which is when the tenant can terminate the lease. There's a duty to pay rent. So a tenancy at sufferance arises upon breach. And then there is a duty not to use the property for illegal purposes. If tenant uses premises for an illegal purpose, landlord may terminate the lease or obtain damages or injunctive relief. Occasional minor illegal activities do not constitute a breach. Liability to third parties and tort. So a tenant may be liable for injuries to third persons from the dangerous condition within the tenant's control. Then there's fixtures. So once movable chattel that is annexed or affixed to real property such that it becomes part of the realty, so often arises with leaseholds but applies to all real property estates. Fixtures pass with ownership of the land. So an exception is a life tenant's representative may remove annexed chattel within a reasonable time after the life tenant's death. So determining whether chattel has become a fixture is intent control. So the annexor's intent is usually determinative. Fixtures almost always arise where annexors affix their own chattel to their own property. So the chattel integrated into a structure, so like heating pipes, bricks built into a wall, almost always become a fixture. Then there's the landlord-tenant. So an agreement between a landlord and a tenant is controlling if it exists. So a tenant installation. So a tenant may remove chattel she installed if one, removal occurs before the lease expires, and two, removal does not cause substantial harm to the property. If tenant impermissibly removes fixtures, she commits voluntary waste. Then there's the landlord remedies for tenant breach. If tenant breaches his leasehold duties, landlord has the option. It depends on whether the tenant remains in possession, so remains on premise. The tenant remains in possession, the landlord may A, file for notice of eviction, or B, continue to lease and sue for rent due. Then if a tenant abandons the premise, landlord may A, surrender, treat the abandonment as a tenant surrender and accept it, releasing the tenant from the lease. B, ignore, which is the minority rule, hold the tenant liable for unpaid rent, or C, re-let. So this is the majority rule. The lease premises is new to the leased premise to the new tenant and hold the breaching tenant liable for any losses. So no self-help. Landlord may engage in self-help upon tenant's breach. So forcibly removing tenant or tenant's belongings, changing locks, etc. Security deposit. Required at the beginning of most leases to secure landlord against damages and or abandonment. Landlord must return deposit to tenant once lease terminates. Landlord may subtract damages she has suffered. Retaliatory eviction. Landlord is promised from retaliatory eviction if the tenant lawfully reports housing code or other violations. Landlord's duties and warranties. Landlords have the following implied duties to the tenant. 1. A duty to deliver possession on the first day of the lease. This is the majority English rule, actual possession. Landlord must deliver physical possession to the tenant. The minority American rule is legal possession, which is right to possess. New tenant is responsible for evicting a holdover tenant. Tenant's remedy for breach is monetary damages, implied covenant of quiet enjoyment, implied warranty of habitability, and tort liability. Implied covenant of quiet enjoyment is when a tenant has implied rights to quiet use and enjoyment of the premises without interference from the landlord. Breach occurs by actual or constructive eviction. Breach may occur by landlord's wrongful conduct causing loss of use and enjoyment by tenant. Actual eviction. Landlord wrongfully evicts or excludes tenant from property. Constructive eviction is when the landlord's actions or inactions render the property uninhabitable or unusable. Elements include 1. Breach of duty. Landlord breached a duty to the tenant. 2. Substantial interference. This is the major and or chronic problems such as a leaky roof are caused by landlord's wrongful conduct. 3. Notice. Tenant must inform the landlord and give him a reasonable opportunity to repair. Landlord must fail to act meaningfully. And 4. Vacate. Tenant must vacate within a reasonable period after the landlord fails to repair. Then there's the implied warranty of habitability. This is for residential property, must be fit for basic human dwelling. Characteristics are residential only, not applicable to commercial leases. Then there's absolute duty. It cannot be modified by lease terms. Local code or case law specifies the standard for breach, and no heat in winter, no plumbing, no water are types of problems that could arise to violate the implied warranty of habitability. Tenant remedies. After giving notice to landlord, tenant can 1. Move, vacate the premises and terminate the lease. 2. Repair, make reasonable repairs and deduct costs from future rent. 3. Reduce or withhold rent, reduce rent or stop payment until a court determines the fair rental value given the breach. And the tenant must place withheld rent in escrow. 4. Remain. So the tenant can remain in possession and seek monetary damages. Landlord tort liability to tenant. A landlord may be liable to tenant for injuries occurring on leased property. Landlord is liable for injuries involving 1. Common areas, duty of reasonable care. Landlord must exercise reasonable care in maintaining and repairing common areas such as hallways and stairs. There's 2, the latent defects. There's a duty to disclose. Landlord has a duty to disclose hidden defects he should reasonably know of. 3, assumption of repairs. There's a negligence standard. Landlord is liable for harm caused by negligent repairs he chooses to undertake. 4, public use. Landlord is liable for known defects if he knows the property is for public use and tenant is unlikely to repair, such as the concert hall or convention center. And then 5, seasonal or short-term lease of a furnished dwelling. So landlord is liable for defects that cause harm to the tenant. Then there's assignments and subleases. Unless restricted by lease terms, a tenant may transfer her leasehold interest in whole by assignment or in part by sublease. An assignment is the entire leasehold, both the duration and physical area, transfers from tenant to assignee. Assignee is in privity of estate with the landlord. The two are bound by all covenants that run with the land. Assignor remains in privity of contract with landlord. Assignee owns rent directly to landlord, but assignor remains liable for unpaid rent unless landlord expressly releases tenant, which is a novation. Sublease, partial leasehold transfers from sublessor to sublessee. Sublessor is in privity of estate and contract with the landlord. This relationship between tenant and landlord is unchanged. Sublessee pays rent to sublessor as her tenant. Sublessee is not liable to landlord for rent and is not bound by any lease covenants unless expressly assumed. Assignment and sublease provisions. Construed against the landlord, lease provisions restricting assignment or sublease are enforceable but generally construed against landlords. Once landlord gives a tenant permission to assign or sublet, such provisions are thereafter waived.